All right, we'll pass on now to our last case, Johnson versus EPAC Custom Builders.
Please, Court. My name is Bruce Snow. I'm an attorney practicing in Brooksville, Florida, representing the appellates in this case, a dispute between homeowners and a general contractor that arose out of the construction of a home in Hernando County. This matter is now on appeal. Two issues have been raised following a jury trial. The first issue that we have raised was the trial court directed a verdict on the issue of whether or not punitive damage claim brought by the owners would be submitted to the jury. The case had involved a contract for the construction of a house, and after a dispute arose, the contractor filed a final contractor's affidavit pursuant to the construction statute, and then filed a claim of lien, and then filed a lawsuit for breach of contract and for foreclosure of the claim of lien.
Well, now, there's no real debate, though, about whether or not your clients cooperated with the contractor with respect to the contractor's affidavit. They couldn't get at their financing without that, could they?
Well, I think that's a disputed issue of fact, Your Honor. That certainly the appellees contend that
I thought that was undisputed.
I view it, the appellate views that as a disputed issue of fact, that there was testimony from the owners that at the closing where there was the affidavit given that the owners were surprised at what had happened in regards to a claim that there was additional monies due. So we view the transcript, we view the evidence.
Was that issue presented to the jury?
The issue of
the cooperation between the client and your client and EPAC?
The testimony in regards to what had happened.
I mean, the jury found that in favor of EPAC on the contract claim.
On the breach of contract claim, yes, Your Honor. The case ended up going to the jury solely on the conflicting or the competing breach of contract claims.
Right. And the lien claim was disposed of.
Exactly. The trial court had entered a ruling granting the motion for directed verdict on the foreclosure of the lien because the court found that the lien was a fraudulent lien, and therefore said that the claim for foreclosure of lien was dismissed effectively, directed verdict dismissing the claim for foreclosure of the claim of lien. It was then the question was whether or not the punitive damage claim should go to the jury. As the court is aware, under the construction statute 713.31, the legislature has created a statutory right to punitive damages in such situations as there is a fraudulent lien. So,
is that mandatory?
The determination of whether or not punitive damages are awarded is not mandatory as such. It becomes a question for the trier of fact to determine in the trier of fact's discretion as to whether or not the facts would support an award of punitive damages. Of course, the statute limits punitive damages to the amount set forth in the claim of lien. And the position of the appellant is that the error that was committed was that the court had found that the lien was a fraudulent lien, and that therefore, that being the case, there was indeed a statutory right to punitive damages. So the question of fact should go to be determined by the jury. Yes, Your Honor.
Refresh my recollection. How did you raise the issue of punitive damages?
Punitive damages, That was raised.
A separate complaint?
No, Your Honor, that was a counterclaim to the complaint that was filed by the contractor. So that was raised initially in the very initial pleadings. The owners sought a breach of contract claim, also raised it as a count in their counterclaim for punitive damages under the statute.
Could I inquire? So you're saying that the owners did not entice the contractor to file a false affidavit, or ask them to because of the mortgage?
That's what we believe that the testimony establishes at trial. Now, certainly the contractor asserts that they were enticed, but that is an assertion that is disputed by the owners. And because it's a disputed fact, that issue should have gone to the trier of fact. And the owners had, the contractor had asserted that they were effectively duped into signing the final contractor's affidavit. We, again, believe that that's a disputed fact that should have been determined by the jury. But even if that was the case, because the allegation, the testimony from the trial was, well, you signed this document, said that you would pay additional monies in the future. Well, that may have been a contract or a supplemental contract between the parties, but that does not indicate any wrongdoing on the part of the owners. So again, on that issue, the appellants believe that the court should have allowed the trier of fact to make a determination as to whether or not there should have been an award of punitive damages.
Did the Johnsons testify during the trial?
Yes, they did.
All right, maybe I missed it, but didn't they testify that they approached the contractor and say that they needed, in order to be able to get the money, they needed the affidavit?
That's not my recollection of the testimony. My recollection of the testimony is that the owner's position was that they had a fixed contract, and that their expectation was that the house was going to be built for what the contract was. They went to the closing and were told, well, you're not going to get possession of your house after an approximately 18-month construction period. You're not going to get possession of the house unless you sign these documents, including some form that says we will get additional financing. And the Johnsons testified that they felt, because of the passage of time and their desire to move forward, they did in fact sign that document saying that they would seek additional financing. But from the standpoint of them approaching the contractor, the Johnsons did not testify to that situation. That would have been something that perhaps the contractor might have testified to, but again would have been a disputed issue of fact.
What would be the incentive for the contractor to do the affidavit then?
To get, for example, to get the last draw that would have been due under the original construction contract. The contractor's affidavit is not only given to the owner, but is also given to the bank and the title company who was involved, so that the bank would give the last draw to the contractor. So the purpose of doing that would be for the contractor to obtain the final draw from the bank.
Is it your view that you'd be entitled to punitive damages even if the owners of the property knew that the affidavit was fraudulent and asked the contractor to file that affidavit so they could get the final draw?
Your Honor, if the owners...
Let's assume that the owner and the contractor got together and they said, look, the owner said, we can't pay you guys until we get the final draw. The only way we can get it is for you to file a lien so that we can claim that, and everybody agrees knowing that it's not an accurate representation of the facts.
I think if the owners had knowingly and willingly conspired with the contractor to create a false affidavit, I think equity would then step in and would prevent the owners from recovering punitive damages.
Is that what happened here?
No, Your Honor. The owners again, went to the closing in expectation that they were going to close on their house, be able to move into the house at the time of closing. And that's really when the dispute arose as to the amount that was due under the contract. There's no indication that they knew in advance that they was going to be a final contractor's affidavit. I wouldn't be surprised, I don't think it came out as such, but typically homeowners not even aware of a contractor's obligation to file a final contractor's affidavit.
Yeah, but you see, it would make absolutely no sense for a general contractor to file a contractor's affidavit indicating that everybody had been paid if everybody hadn't been paid. I mean, you know, ordinarily what happens is if the property is financed, contractor goes down to the bank holding a copy of that final contractor's affidavit, and they very carefully exchange the things. It really doesn't make sense for a contractor to do that. Now, I know that the trial judge directed a verdict on the punitive damages claim. What did he say in directing that verdict? I mean, did he make any findings?
Your Honor, as I was both there live at the trial and also as I reviewed the transcript, I didn't see any findings that the trial judge made in directing the verdict. He just ruled that he was going to direct the verdict and that the issue of punitive damages would not go to the jury. And
did he find that the Johnsons had participated in the inducement of the execution of that?
I'm not aware of any finding from the trial court that makes a finding either in writing or pronounced from the bench that the Johnsons had procured a false affidavit. That was a disputed issue of fact that needed to go to the trier of fact in that regard. And Your Honor, going back to the incentive of the contractor to give a false affidavit, again, if he's desirous of getting the balance of the construction funds paid to him, that would be an incentive for the contractor to give an affidavit that says that there are no liens that are due.
Well, that would be true if the balance of the construction funds equaled the amount of his contractor's affidavit. But if the contractor's affidavit was more than that, it would make no sense at all.
May very well not. Again, on that issue, we respectfully would contend that the trier of fact should have been given the opportunity to determine whether or not there was punitive damages, given the fact that the court determined that there was a fraudulent...
Was the jury instructed on punitive damages?
The jury was not, Your Honor.
Was not?
The jury was not instructed on punitive damages.
So the ruling was made before the jury ever even considered it?
That's correct. That issue did not go to the jury. There was no instruction to the jury on punitive damages. The second issue that we raised is the issue of the consequence of the false contractor's affidavit, that the false contractor's affidavit under the statute is a condition precedent to a contractor coming into court and seeking to obtain the benefit of the judiciary from the standpoint of enforcing a claim. Since that condition precedent was admittedly false, it was admitted that it was a perjured affidavit. It was admitted that that would have constituted a felony in the third degree. For a condition precedent to the filing of litigation to be predicated upon a blatantly false contractor's affidavit is the exact type of thing that would constitute fraud on the court. And it's our position that the court should have dismissed all of the contractor's claims.
What does the contractor's affidavit have to do with a contract claim?
There's certainly separate matters as such. The foreclosure of the construction lien is predicated on the contractor's affidavit. The breach of contract is a separate matter. But the decisions that we cite in our brief, I think, would stand for the premise that once somebody has initiated litigation through a fraudulent device that has permeated the entire proceedings. And once it's permeated the entire proceedings, that it is required that there be a dismissal. We recognize the fact that a dismissal for fraud on the court is a matter that...
I think that might be a discretionary...
It is a matter that is discretionary with the court, and it's to be reviewed on an abuse of discretion standard. However, we would cite the case of Honono versus Murphy, which is in our brief, where the court determined where fraud formed the foundation of the action in the first instance. It was an abuse of discretion for the court not to grant a dismissal of the litigation. We also suggest that the case of Taylor versus Martell, which again is in the brief, indicates that when you have a licensed professional who is licensed by the state of Florida, and that licensed professional creates false and fraudulent documents in order to get into court in the first instance, that results in fraud permeating the entire proceeding, and that matter should then be dismissed, and again, we believe applying the abuse of discretion standard. I would like to, unless there's some additional questions, I'd like to reserve my additional time.
You have about 4 minutes left.
Very good. Thank you. Appreciate you hearing us.
Good afternoon.
Good morning.
Please the court, counsel. Good morning. I guess it is still morning.
Unless you've been working all night, it'll be afternoon, right?
I had a judge tell me one time, he says, "Don't worry about it, I'm just as confused as you are." So.
My name is George Angelitis. I'm an attorney practicing out of Brooksville, Florida. I represent EPAC Custom Builders Incorporated in this case. Represented them prior to becoming involved in this litigation, still represent them. The principals of EPAC Custom Builders are Mark Kundrat and Andy Colombino. And that's pertinent because Mark Kundrat, the vice president of EPAC, is the brother of Felicia Johnson.
Why is that relevant to any issue in this case?
I think it goes to the reason, as the court was asking Mr. Snow, as to why would the contractor do something like this? Why would the contractor sign an affidavit knowing it wasn't accurate? That's why it becomes relevant. This is his sister. And it came out in court, in the trial, in the testimony, that there were problems with the financing. Mr. Kundrat had to co-sign for the loan initially before he could be removed from it. There came a point in time prior to May 7th, and it was discussed prior to closing that, and it's in the transcript, it's in the testimony, you are behind. You are so far beyond on your extras, you're not going to have enough to close with the final draw. What are you going to do about it? And Ms. Johnson and Mr. Johnson both acknowledged these particular conversations prior to closing. They thought it was $17,000, but as was explained during the testimony of the case by Mr. Colombino and Mr. Kundrat, the bills were still coming in. And that was the reason that this document was signed. And this document clearly indicates, it's May 7, 2003, Gary and Felicia Johnson hereby agree to pay the remaining proceeds due to EPAC Custom Builders Incorporated by securing a second mortgage within 30 days of the closing of their first mortgage with Capital City Bank. Due diligence is required regarding this issue, and the proceeds due were calculated by assessing any and all costs related to construction of their new home at 6151 New Osprey Point, Weeki Wachee, Florida, and deducting all proceeds received up to and including the aforementioned closing.
Well, I guess what I want to know is,
Yes, sir.
did the Johnsons in their testimony at trial acknowledge that that they had induced the EPAC to submit a fraudulent contractor's affidavit?
Yes, sir, I believe they did, and it's in my brief. Owner Gary Johnson testified at trial that he never intended to pay for any of the extras despite signing the agreement. And that's in the transcript at 394 and 395.
That doesn't address that he induced a fraudulent affidavit. That just demonstrates that he's not a very good guy.
Well, Further in my brief, I explained that Mrs. Johnson, when describing her execution of the agreement, testified that, quote unquote, it was a deception. They induced, and I think the testimony of my clients was pretty clear, and I believe the testimony of the Johnsons was pretty clear, that the reason for this document being signed was to facilitate the closing. Otherwise, they weren't going to be able to close. They didn't have sufficient funds to pay for the extras that they had incurred. And as the court had questioned Mr. Snow regarding, is there anything in writing regarding the final judgment or the decision of the court to direct the verdict as to the punitive damages, there certainly is in the final judgment.
How was that affidavit used? It was used to induce the lender to make a final draw, wasn't it?
That's correct.
So as to the lender, it was misleading, false, fraudulent, whatever you want to call it, wasn't it?
Right, and neither the lender nor the title company are parties to this action. They never filed any sort of claim or cross-claim or asked to enter into the proceedings in any way.
Well, isn't one of the purposes, though, of the statute that allows punitive damages, though, to stop the practice of misleading a lender?
I think the purpose of punitive damages is to punish somebody who has taken willful steps to somehow defraud.
But the statute doesn't say that it's limited to fraud against the owner. It can be fraud to anybody, the lender or anybody else, can't it?
It could be fraud against them. But again, those folks aren't parties to this action and never asserted any sort of claim.
I don't know whether that makes any difference or not, as long as you're trying to punish somebody for fraudulently inducing a lender to making a final draw.
I think what the crux of the issue is this particular affidavit that we're talking about was done with the knowledge of the Johnsons, and it was done for a specific purpose, and that was to close the transaction so they'd be able to go back, because the house that my client built for his sister at cost had so much equity built up in it, it was going to be easy for them to refinance. And they subsequently did refinance for $90,000 not too long after the closing of the transaction, but didn't pay my client a dime. Now, in the final judgment, paragraph number 4, that the court determined after the presentation of the plaintiff's case that due to the defendant's participation in the inducement of the execution of the final release of lien by plaintiff was entitled to a directed verdict as to the defendant's claim for punitive damages resulting from the fraudulent lien.
What's the substantial competent evidence that supports that conclusion?
I think that the testimony of the witnesses, Your Honor, in
what specific testimony?
The specific testimony of them admitting that they signed this agreement at the closing, inducing my clients to sign the affidavit without...
Did they specifically say that they did that to induce your clients to sign the affidavit?
No. No, and I previously read what it does say, and it's in my brief, and he said that even though they signed it, they never intended to pay for any of the extras, even though they signed the agreement. And that's what Mr. Johnson testified to. And Mrs. Johnson testified that it was a deception. And they knew it was a deception going into the closing. And I think the reasons that I've enumerated in my brief, and I've enumerated here today before you, of the contractor entering into this agreement in the first place, if it is relevant as to the relationship of the parties. These weren't strangers coming into this agreement. I think another telling point is that my client received from the jury every single penny they asked for after hearing all of the evidence. They denied appellant's claim of breach of contract, awarded him a 0 verdict. I think what was discussed in my brief holds true with regard to the standard that has to be borne by the appellant to even be entitled to punitive damages. And that is they have to demonstrate by clear and convincing evidence that they're entitled to it prior to even being able to move forward to a jury, to the trier of fact in this case. The judge has the ability to determine if it's appropriate after considering whether or not the appellant has presented clear and convincing evidence that they are entitled to it. And I think the case that's instructive is the bankruptcy case that I cited, the M.B. Hayes case at, sorry, I just lost the page, 305 Bankruptcy 361, and it's a Middle District of Florida case from 2003, which Judge Merritt, the trial court judge, directed us to after the initial motion for directed verdict by Mr. Snow. And in that case, it's pretty clear, the court was placed in a position of determining whether the property owners were entitled to punitive damages under Florida's fraudulent lien statute. And in Hayes, the court made a determination that the contractor had included improper amounts within its lien, which rendered it fraudulent and unenforceable pursuant to 71331. This lien was not determined to be fraudulent because it included excessive amounts or amounts for work that had not been done. It was deemed to be fraudulent by virtue of the fact that they signed this initial contractor's final affidavit, which they knew to be false at the time, which they testified to. They never tried to permeate the proceedings with a falsehood, and I'll get to that issue later. The Hayes court went on to determine that the contractor submitted a fraudulent lien. The property owners argued that they were entitled to punitive damages as a matter of law. The court went on to state that it is well established that the law of punitive damages does not automatically flow from the finding that a construction lien was found to be fraudulent. And that's part of what the Hayes court decided, and that's part of what I believe Judge Merritt decided, is that because the defendants, or the appellants in this case, participated in the fraud, they should not be rewarded for that participation. I think it really is that clear. As far as permeating the entire proceedings, Mr. Snow's second point of appeal, in that the trial judge should have thrown out all of my client's claims based upon this fraudulent affidavit, I raise a couple points. First of all, in his initial motion for directed verdict, which is contained in the transcript, that motion for directed verdict is to count 2 only. Is not to the breach of contract claim. He raises the fraud issues as to count 2, the foreclosure of a statutory lien. Does not raise it as to the breach of contract. That's number one. Second, he indicates that in his brief that he mentions it in his prayer for relief in his motion for judgment notwithstanding the verdict. There's no transcript of those proceedings. While it may be in the prayer for relief, I think he's waived that argument. I believe it's moot at this point. However, if the court wants to address that issue, I would point it to Ruiz versus the City of Orlando, a 5th DCA case from 2003, which discusses the leading case in this particular issue, Cox v. Burke. In the Ruiz case, the court discusses Cox v. Burke and indicates that it's a leading case in this district governing the dismissal of civil lawsuits based on fraud. In Cox, we anticipated, although we apparently underestimated, the seductive power of this remedy. We took pains to try to express how narrow it should be. And it goes on to talk about the requisite fraud on the court occurs where it can be demonstrated clearly and convincingly that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability impartially to adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the presentation of the opposing party's claim or defense. That didn't happen here. They knew about this affidavit being executed because they were there when it was done. They knew the circumstances surrounding it from the time the complaint was filed, from the time they received the claim of lien, from the time they received the second contractor's final affidavit, which included the $52,000 amount. This was no surprise. My clients didn't testify contrary in a deposition or try to hide behind the fact that there was a second affidavit filed. They clearly owned up to the fact that, yeah, we signed this thing, we made a mistake. And I think that's relevant because obviously this isn't a situation where my client's trying to perpetuate a fraud on the court. And I think that would be an extreme measure as discussed in the Ruiz and the Cox cases, which this court has opined on. And I'll just finish up with the last part of the Ruiz case. Except in the most extreme cases where it appears that the process of trial has itself been subverted, factual inconsistencies, even false statements, are well managed through the use of impeachment and traditional discovery sanctions. The record in this case does not demonstrate clearly and convincingly a knowing and unreasonable scheme to interfere with the judicial system's ability to impartially adjudicate the claim. And that's what happened here. We were able to impartially adjudicate the claim. The jury was able to hear the evidence. The judge was able to hear the evidence. There was never a motion to dismiss in this case for fraudulent lien. There was never a motion for summary judgment in this case for fraudulent lien. And I don't believe that the actions taken by my client rise to the level to be able to strike their entire cause of action. If there aren't any other questions, I'd like to reserve the remainder of my time.
Thank you. Counsel, you have a little more than 4 minutes.
Very good, thank you. I think the major concern in this litigation is that we have a general contractor who executed a knowing false affidavit. That's a condition precedent to access to the courts of Florida. A licensed professional in the state of Florida. There's a lot that has been argued by the contractor to try to deflect the responsibility of the contractor, who knew better than to give a false affidavit, recognized it was perjury, recognized it was a felony. It's that wrongful conduct that should not be countenanced by the courts of this state. The blame is tried to be deflected on the homeowners. Comment was made that Ms. Johnson, when asked about that document that was signed, said there was deception. However, in the transcript on page 538 and 539, Ms. Johnson testified that she felt deceived by an EPAC. So it appears that completely looking at her testimony, it was she that felt deceived. And again, the question goes back to whether or not the Johnsons induced a fraudulent contractor's affidavit. There's no evidence to indicate that they induced a fraudulent contractor's affidavit. There may be evidence that they had agreed at closing to pay additional sums in the future, but there's no evidence that they induced a false and fraudulent contractor's affidavit.
But the jury did find for the contractor and gave them the extras, right?
The jury deliberated in a vacuum. The jury was not instructed as to the fact that there was a fraudulent lien. The jury was not instructed in the fact that there had been a claim for punitive damages. It's our position if the jury had received the punitive damage claim as the trier of fact on the disputed facts, that very well would have impacted the jury's view. They may have offset an award by virtue of also awarding punitive damages. They may have viewed the entire case differently if the issue of the false contractor's affidavit, the punitive damages, the fact the court had determined the lien to be fraudulent. If the jury had that information, it would be reasonable to conclude that there would have been a different result. But it comes back to the issue that there's disputed facts on that issue. The trial judge in this case is an excellent trial judge, and 99.99% of his rulings were right on point. However, it's not for the trial judge to weigh the credibility of the witnesses on whether or not there was inducement, whether or not there was a subsequent contract, and issues of that nature. What the trial judge did know is that there was a blatantly false contractor's affidavit that was a condition precedent, and the access to the courts, we would respectfully contend, should not be awarded to contractors who knowingly give false, fraudulent, perjurous affidavits in order to get into court. Thank you for hearing this.
Thank you. That completes our docket for today, and so we are in recess. Or I guess we're adjourned.